final canon, and this is maybe my favorite. It's certainly the one that I've noticed over the years that dealers are most scared of, and that is litigation. And you can see how much more energy I have in this one because it's really where I get amped up and where lawyers become battle tested, right? This is where the competition aspect of being a lawyer comes into play. So we're gonna do a handful of videos on litigation, and then you're done. You've completed the course. So congratulations, maybe premature congratulations because you're not done yet. Let's start in litigation though with common terms. And we're gonna go plaintiff, defendant, complaint, answer, counterclaim, and judgment. Plaintiff is the party that files the lawsuit. In the case of a consumer suing a dealer, the consumer is the plaintiff. In the case of a finance company suing a dealer, the finance company is the plaintiff. In the event that a dealer is suing a customer, let's say for a deficiency, then the dealer is the plaintiff. On the flip side of that is the defendant. The defendant is the party that's being sued. So if the customer is suing the dealer is a defendant. If the finance company is suing the dealer is a defendant. And if the dealer is suing a customer, the customer is a defendant. That's plaintiff and defendant. Now, the complaint is another word for the lawsuit. That's what lawyers call the lawsuit, the complaint or the statement of claim. All three are the same thing: lawsuit, complaint, statement of claim. The answer is what is filed by the defendant in response to the lawsuit. Now, in Georgia, we have 30 days to file an answer. If you don't file it within 30 days, you go into default. Okay, that's another word. Well, why don't we throw that in there as a bonus, default. So we have 30 days to file an answer. If the defendant doesn't file an answer within 30 days, they go into something called default, which is when they've admitted every allegation in the complaint. This is a big problem for defendants. It's very important, if you're a defendant, to file within 30 days. Now, you do get an extra 15 days as a matter of right, so 45 total, to file the answer. Those last 15, though, you have to open the default by paying the court costs. So let's say it's a $300 court fee. Then the defendant would have to pay $300 to file their answer. So that's the 45 days. After 45 days, the plaintiff can move for a default judgment. And we're going to talk about judgment in a second. But that's the answer, right? They have 30 days, then another 15 days. Now, a counterclaim would be included in the answer, and it would be a claim against the plaintiff by the defendant. So sometimes, let's say it this way. This is a very common example. Customer buys a car. Something's wrong with the car. Customer stops paying and then sues the dealer and says, you owe me $5,000 for the problem with the car. Well, the dealer says, hey, hang on a minute. You haven't made your last 2 months of payments. You owe us $800. That would be a counterclaim that would be filed against the plaintiff as part of the answer. Now, a judgment, default judgment is a type of judgment, but a judgment is really just a sheet of paper signed by a judge awarding money to one side or the other. Could be awarding money for the plaintiff if the plaintiff wins. Could be awarding money for the defendant if the defendant wins on a counterclaim, or for a handful of other reasons, something like attorney's fees or other things. A defendant could be awarded damages. But that's contained in a judgment. Now, the biggest challenge in litigation, besides litigation itself, which is, I guess, big enough challenge, but one of the biggest challenges is actually collecting, because all a judgment is, like I said before, is a sheet of paper. Nobody walks into court with a briefcase of money that they have to give over if they lose, right? They walk into court, they make their argument, a sheet of paper is issued, and then they have to pay on the judgment. So collecting can sometimes be very difficult, especially against customers or folks that just don't have the resources, right? If the money's not there, it's hard to collect it. So those are common terms of litigation. Next, we're going to talk about common claims.